So you're an injured worker with a workers' compensation case in Virginia, and you're being held out of work 100% by your doctor due to a serious injury. And you're under an award, and you're receiving your weekly checks. Now it comes to a point, due to pressure from the nurse case manager, and the nurse case manager, who are they? We have other videos on this, but they're basically the liaison, or the mouth, you could really say, of the insurance company, and they communicate with your doctor. And under pressure from this nurse case manager, they try to get you to return to some kind of light duty work. They put pressure on the doctor and says, okay, yeah, we can put a lifting restriction of 10 pounds on you. You can go to full-time work, but we don't want you twisting, bending, stooping, or ladder climbing. Sedentary work only, sitting at a desk or something like that for 8 hours a day. Okay, so full-time work, but light duty. The job that you had, let's assume, before you got hurt was pretty heavy stuff. So you definitely can't go back to doing that. But after that doctor's visit, okay, your employer gets a copy of that work note. Okay, they get a copy of it, and they call you up and they say, hey, guess what? We got a light duty position for you that we think we want you to do here full time, and you come on in Monday. That's your first day back. Okay, so you come back to work in this light duty position, and what is it they got you doing? They got you sitting at a desk doing stuff that doesn't really seem to matter much, basically a BS job, but it's within your physical restrictions. Now, your supervisor at this job is someone who you hadn't worked with before, clearly hates the fact that you're there, or appears to hate the fact that you're there, and begins to clearly harass you every single day. What has happened and what can you do about it? I'm Joe Miller, workers' compensation attorney in Virginia, North Carolina. Today, specifically, we're going to talk about a phenomenon, specifically in Virginia, that I call accommodation. Accommodation by the employer of your physical restrictions. This is where the employer decides to accommodate your physical restrictions as set forth by your authorized treating doctor by bringing you back to work within those restrictions. So, in most cases, I've found over the years, I think really for safety reasons, employers generally will not accommodate you. They just say, look, we don't have no light duty over here. Also, sometimes there's pressure from the insurance company saying, look, don't let him back on the property. Why? Because we still insure that property, and if that person gets hurt again, then we're going to have to deal with another claim. So what happens then? If the employer says, we don't have any light duty for you, if you're under an award and you're already receiving checks and it's an open award, those checks are going to continue. Nothing's going to change because the reason you can't come back to work is because of your injury. That's not what we're talking about here, though. Here we're talking about a time when your pre-injury employer, your original employer where you got hurt, orders you back to return to work on a light duty job. There's a concept in workers' comp, specifically, and in Virginia, this is especially important, called selective employment. Okay, what does that mean? It means you haven't returned to full duty work, but you're returning to some kind of modified work, either at the direction of your employer or the direction of a voc rehab counselor. Okay, and it's to accommodate your light duty restrictions. Either way, it's called selective employment. Now, why is this significant? Because if you are fired for cause from selective employment or you quit that job, that's considered, the term is a refusal, means you have refused that job. It's just the same as saying, I ain't going back to no light duty job. I'm not doing that. It's considered the same. And that pretty much spells the end of your workers' comp case. Because from that point forward in Virginia, other than being taken out of work 100% by your doctor, unless that happens again, you're never going to get another check while you're on light duty, ever. You have just basically ended your workers' comp case. Why? Because the way the law looks at it is the reason that you're not working has nothing to do with your physical restrictions. It's because you quit, buddy, or you did something at work that they didn't like, that you screwed up, so you're fired for cause, not because of your injury, and that's why you're not able to work. That's the way the law looks at it. So what that means is that accommodation by the employer is very dangerous for your workers' comp case. And in fact, whenever we see it happen, we dread it, okay? Because we know we're in for a bit of a rough ride. Because unless the employer is paying you less than, unless you go back to that light duty job and they're paying you less money, okay, in which case you're still entitled to 2/3 of the difference. They bring you back, let's say they only going to pay you or bring you back for 30 hours a week or 20 hours a week. They still owe you 2/3 of the difference between what you were making before and what you're making now. That's what's called temporary partial disability, okay? So there will still be some checks they have to pay you. But most of the time, that's not what they do. They bring you back the same pay. The reason they do this is basically to put you in a situation where you're being harassed they want to treat you poorly. They're going to give you stupid jobs that you don't want to do to piss you off. Really, the end of the bottom line is to piss you off. So hopefully they'll get a rise out of you. You will respond in kind if the supervisor makes some kind of comment. Now you've committed insubordination. Okay, they can fire you for cause right then and there for that. You talk back to the supervisor, boom, you're gone. Okay, and again, as I said before, that pretty much means the end of your comp case. Is that fair? No, it's not fair. Terrible, but they can do it. That's the end of the question as to why the employer is accommodating you. They want you to get cut off because you're going to either get so frustrated that you quit, or you're going to sass back to your supervisor, and that's going to be the end of it. As we discussed in other videos that I encourage you to watch, what goes into a settlement demand in a workers' comp case, the value of your claim is based on a number of factors. Okay, one of the big ones is how many weeks do you have left in your award of potential temporary total disability checks, those weekly checks you get. How many do you have left? Okay, you can get up to 500 weeks. Okay, unless you've got a really crazy, permanent and total case, which is very rare, you can get up to 500 weeks. So, for example, if you were out of work for a year, okay, and you're released to light duty, and they take you back, you still potentially have up to 448 weeks left, okay, because you have 52 weeks, that's a year, minus 500, that's 448 weeks left remaining under your award, okay? So that means the carrier's on the hook financially, potentially, for that, unless they can get you a job with any restrictions or your doctor returns you to full duty, right? So just think about that for a second. Let's say your workers' comp checks, 2/3 of your average weekly wage, okay, are $500 a week. Let's say they're $500 a week. So in our example, that's 500 times 448. That's $224,000 potentially of future monetary obligation that the workers' comp insurance company has to you. Okay, yes, it's one check at a time per week, but and they're not going to pay all that if they want to settle the claim. They're not going to pay every bit of it, but they'll pay part of it to settle the claim if they're obligated to pay it. But if they can get you cut off of that money and they don't have to pay it anymore because you went in there in light duty and you were fired or you quit, you can say goodbye to that 448 weeks. It is gone. I'm not saying that accommodation by the employer is always for some nefarious purpose. From time to time, you might be accommodated because they have a legitimate need to fill a position that they've got over there. That, even though you're on light duty, they really need your help. But more often than not, in our experience, the purpose behind accommodation is to get you fired for cause, either by way of harassing you or catching you in some kind of obscure rule violation or whatever it is. So why am I telling you this? Because you got to be prepared to face abuses from your employer for harassment, and understand the real purpose behind these abuses is not at you personally. Realize what they're trying to do to your case and why they're trying to do it. Because if you respond in kind or you outright quit, you just handed the insurance company your whole case. Okay, you don't want to do that. So we make sure to tell our injured workers who are our clients to go back, follow all the safety rules set forth by the employer, and only work to the letter within the restrictions that your doctor gave you. Don't go beyond the restrictions. Now let's say the workers' comp insurance company has accommodated you, but one day they come to you and they say, okay, we really can't accommodate you anymore. Sorry, we're going to let you go from the light duty position. That's okay as far as your case is concerned, because that's not being fired for cause. That's being let go due to their inability to accommodate your physical restrictions anymore. Fortunately, the Virginia Workers' Compensation Commission foresaw a problem and they've passed laws to protect you on this. So think about this scenario for a second. You've returned to full duty, you're getting your checks, now you're full duty, and they file a paper that says, okay, let's stop his checks because it's full duty. Within 24 months, you got to, so like another 2 years, you got to file that thing from the date of your last check. That's the way the law works. So let's say now that in this particular situation, a crafty employer does this to you. Says, hey, here's what we'll do. We're going to put this guy in a BS job for 24 months. This does not apply to a full duty job. This only applies to a light duty job. At the end of the 24 months, we're going to fire him, okay? And then his statute of limitations will run out, and we'll be clear from paying him another penny, okay? And now cue the evil laugh, because that's what they would do, right? Mwahaha. The Virginia Workers' Compensation Commission, fortunately, saw this as a potential issue. So they passed a special exception. And they said to employers, no, you can't do that. You're going to bring an employee back on light duty. His 24 months is suspended for up to 24 months. For the entire time that for up to 2 years that he works for you, whatever clock started, okay, it stops for that 2 years. So you think you can go ahead and wait 2 years? No, no, no. It don't even start again until the end of the 2 years. And then you got another 2 years. And if you want to look it up, this is actually if you want to look at it's found in Virginia Code 65.2708C. Virginia Code 65.2708C. We actually want to have this happen, okay? And the adjuster did not know the law. They had our client come in working a BS job, just like I said, working at a desk job, pretty much doing nothing all day for 2 years. The 24th month from his last check, the employer comes, here comes the supervisor in, ha, 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 ha. We no longer need your services. They figure, hey, he is barred from asking for another penny because the 24 months have expired, okay? But the adjuster was not aware of what this savings provision, okay? You had this guy on light duty for 2 years. That means the running of the statute of limitations was suspended for the entirety of that 2 years. So now he has another 24 months to file his claim. You waited for the whole 24 months. Now he's got another 2 years to file his claim. So because he remained, on permanent light duty, we were going to go ahead and refile, reinstitute his weekly benefits, get him restarted, and we ended up getting a nice settlement for this guy. And again, it's all because the Virginia legislature foresaw this problem of abuse that employers could do where they could bring people back on light duty, wait for the statute to run, and just cut them loose. So I hope this little foray into our concept of employer accommodation in Virginia, North Carolina cases has been helpful to you today. You're on light duty, employers bringing you back, and it's to a weird job that you've never done before. Watch out. So now that we've gone through all these dangers about being accommodated in Virginia in a workers' compensation case, I'm going to mess with your mind a little bit and mess all that up by talking a little bit about how North Carolina differs on this issue of you either being brought back to work and accommodated at your employer with your light duty restrictions and then being fired for cause while you're back there being harassed or whatever, or being fired from some other light duty job that maybe vocational rehabilitation got for you also for cause. Now, I've kind of been reluctant to get into this because it might be a little confusing, but let's just be clear. The law is different in North Carolina on this, and in my opinion, much more reasonable. In North Carolina, this whole concept about worrying about getting fired for cause if you're brought back to the employer or on some other light duty job while you're under light duty restrictions doesn't portend quite as much doom as it did in Virginia. And this is because of a case that came out back in 1996, a North Carolina Court of Appeals case, which is widely known as the Seagraves case. Seagraves, Seagraves, if you want to look it up. Basically, it says that in North Carolina, if you're fired for cause from your light duty job, after you're brought back, either at your same employer or some other employer, unlike Virginia, okay, and I think this makes much more sense, by the way, unlike Virginia, the court is not just going to assume that the reason you can't find any work now, the reason you can't work now that you've been fired for cause is because you got fired for cause. What they do in North Carolina is it's a much more balanced approach. The first thing the employer has to do is they have the burden to show this now. That number one, you were fired for cause, okay, on this light duty job. Number two, anybody else would have been fired for cause for the same conduct that you engaged in, okay, whatever that conduct was. And three, okay, the firing is completely unrelated to your injury. And what they mean there is that you weren't let go because your performance was subpar because you're having a hard time with your injuries, okay? The person was let go because of some unrelated misconduct. You broke some safety rules, you screamed and yelled and cussed at one of your supervisors, whatever. Something completely unrelated. So far, that kind of sounds like Virginia, right? I mean, it's pretty much other than maybe the last thing. And that would be in Virginia, if they can show that, that would be the end of any and all checks for you as long as you remain on light duty, which usually at this point, the person has permanent light duty. Okay, so which means that you probably never get another workers' comp check. But in North Carolina, it's not the same, okay? Why? Because once the employer, let's assume that they're able to show all that stuff, okay? Yeah, you got fired for cause. It's unrelated to your injury, and yes, anybody else would have been fired for the same thing, right? Let's say they could show that. Well, then the burden goes on the employee, okay? And the employee has an opportunity, unlike Virginia, the employee in North Carolina has an opportunity to show that his or her inability to find work is really due to the fact that they have have some pretty bad work restrictions. They've been looking for work within those restrictions, and they're unable to find any. We call that generally marketing your residual capacity to work, which is a fancy way of saying you're looking for work, light duty work. Okay, and as long as you can show that to the commission, oftentimes, most of the time they're going to say, okay, well, this person has shown that their work capacity is decreased. We're going to look at the fact that this person has some pretty severe restrictions and they can't find a job within those restrictions. And that means your workers' comp checks will continue in North Carolina under those circumstances. In Virginia, you're not even going to get that opportunity. They don't care what your work restrictions are. If you're fired for cause, finish. They're going to assume that that's the only reason you can't work anymore and has nothing to do with whatever your restrictions are. I don't care if you can only lift 5 pounds. They don't care. I have several videos, I think, on marketing your residual capacity to work or looking for work. I encourage you to watch those videos. It's interesting that the courts in North Carolina, in the Seagraves case and in the North Carolina Supreme Court case that came later, they specifically say, why are we doing this? Why are we coming to this balanced decision? Because this is open to a lot of abuse by the employer. If we're just going to say that people can be fired for cause and that's the end of your comp, okay, then that's going to give employers an incentive to bring people back and harass them and try to get them fired for cause. They recognize that, and that's why they passed this what I think is a much more reasonable approach to this issue. You or a loved one hurt on the job in Virginia or North Carolina, please don't hesitate to give us a call either about this or any other subject in workers' comp, and be happy to help you. The number, calls on the number on the screen. And have a blessed day. Joe Miller out.